Start. When, like in the present case, the inquiry report is in favor of the delinquent officer, but the disciplinary authority proposes to differ with such conclusions, then that authority which is deciding against the delinquent officer must give him an opportunity of being heard, for otherwise he would be condemned unheard. Full stop. In departmental proceedings, what is of ultimate importance is the findings of the disciplinary authority. Full stop. Under Regulation 6, the inquiry proceedings can be conducted either by an inquiry officer or by the disciplinary authority itself. Full stop. When the inquiry is conducted by the inquiry officer, his report is not final or conclusive and the disciplinary proceedings do not stand concluded. Full stop. The disciplinary proceedings stand concluded with the decision of the disciplinary authority. Full stop. It is the disciplinary authority which can impose the penalty and not the inquiry officer. Full stop. Where the disciplinary authority itself holds an inquiry, an opportunity of hearing has to be granted by him. Full stop. When the disciplinary authority differs with the view of the inquiry officer and proposes to come to a different conclusion, there is no reason as to why an opportunity of hearing should not be granted. Full stop. It will be most unfair and iniquitous that where the charged officers succeed before the inquiry officer, they are deprived of representing to the disciplinary authority before that authority differs with the inquiry officer's report and, while recording a finding of guilt, imposes punishment on the officer. Full stop. In our opinion, in any such situation, the charged officer must have an opportunity to represent before the disciplinary authority before final findings on the charges are recorded and punishment imposed. Full stop. This is required to be done as a part of the first stage of inquiry as explained in Karunakar case. Full stop. The result of the aforesaid discussion would be that the principles of natural justice have to be read into Regulation 7 within bracket 2 full stop. As a result thereof, whenever the disciplinary authority disagrees with the inquiry authority or any article of charge, then before it records its own findings on such charge, it must record its tentative reasons for such a disagreement and give to the delinquent officer an opportunity to represent before it records its findings. Full stop. The report of the inquiry officer containing its findings will have to be conveyed and the delinquent officer will have an opportunity to persuade the disciplinary authority to accept the favorable conclusion of the inquiry officer. Full stop. The principles of natural justice, as observed, require the authority which has to take a final decision and can impose a penalty, to give an opportunity to the officer charged of misconduct to file a representation before the disciplinary authority records its findings on the charges framed against the officer. Full stop. In the present case, the charge against the petitioner was that he had exceeded his jurisdiction by passing the order dated 11/8/2026 and the order was passed for personal gains and to show favor to and in collusion with the private parties, thereby causing loss to the state government and the Gaon Sabha. Full stop.